G'day everyone, I'm James Orr, and today I'm here with Paul Murray, our Legal Practitioner Director at Law Wyze.
James, thanks for having me.
Thanks for coming. There's been some interesting developments this week. Let's dive in.
Well, the big news this week, of course, was Optus lost its application for leave to appeal decision in the federal court. So they applied to the full court of the federal court to be able to appeal an earlier decision. These are what they call interlocutory hearings. So they're not the main event. They're kind of procedural issues that have to be sorted out on the way to the decision. So the underlying case is a class action that's been brought on behalf of Optus customers, arising out of Optus's big data breach back in September 22. One of the things that happened in that case was Optus had, back in 22, commissioned Deloitte to conduct an inquiry into how the breach had happened. The lawyers for the customers wanted Optus to hand over copies of all the relevant documents associated with that report and a copy of the report itself. Optus argued that this was covered by legal professional privilege, which is what we're going to be talking about today, and that therefore they didn't have to hand it over. The federal court initially rejected that argument from Optus. Optus then applied to the full court, the federal court, to be able to appeal against that decision, and on Monday the full court rejected that appeal. So Optus is going to have to hand over the report and, well, at least some associated documents. We'll find out as the court case unfolds exactly what information that they'll have to hand over.
Yep.
It's sort of good news for us because we'll find out a lot more about what happened, but it's obviously bad news for Optus because it means effectively what they've done is they've engaged Deloitte to produce a report that's going to be now used against them. That they've really effectively done the job of the lawyers for the customers. And that's, I guess, what makes it interesting for the rest of us.
Yeah, absolutely. Well, we think about that broader topic of privilege, which is, I guess, very much intertwined with the conversation around the Optus decision this week. How does that sort of weigh in on the broader value of privilege and where it sits in the legal process?
Well, the idea behind privilege is that it's designed to avoid a situation where a client is reluctant to share things with their lawyer. It's there to allow lawyers and their clients to have frank and fearless discussions about things. So you don't want to be thinking, well, hang on, I don't really want to go looking to see how this cyber incident occurred because it could turn out that we were really negligent, and then we'll have to share that with the rest of the world. We want to be able to take that to our lawyer and get advice on it, and we want to go there with as much information as we can. And then if the regulator or lawyers for customers or whoever it is that takes action against you, if they want to start making allegations about things, well, they'll have to do their own investigating. So it allows you to, to focus on getting the answers without holding back out of fear that you're going to uncover something that will then be used against you.
And in this case too, like we're talking about not just like a report in the example that we're talking about. There's all the associated documents too, right?
Yeah, because there'll be when the external body or internal body, it doesn't really matter which, starts conducting it, you're going to have somebody who's doing the incident investigation. They're going to want to request all kinds of logs, all kinds of statements from people. They're probably going to want to interview people. There are all kinds of documents that may or may not end up in the final report. And a lot of those could be really useful to someone who's wanting to sue you for negligence or well, seek a civil penalty for your breaches of the Privacy Act, for example. There are lots of possible implications. I mean, of course, the penalties for breaches of the Privacy Act are really significant now. So, yeah, you can see why any organisation would want to have privilege
Yeah.
over that kind of investigation, because then they don't have to be constantly balancing it. They don't want to say, well, I don't really care. It's happened. I reckon we've probably fixed it. If we go poking around too much, then that'll just make it easier for people to take action against us. So the privilege exists so that you can put that to one side and just get all the answers that you need to get.
And at the core of these proceedings, dominant purpose, became a bit the central component, right?
Yeah, everybody's talking about it now. The test is whether the dominant purpose for creating the document was to obtain legal advice or in preparation for anticipated or actual litigation. So we don't really need to worry too much about separating those out. It's legal advice, whether that legal advice is for a court case or not. If the dominant purpose of creating a document was a legal purpose, then it'll probably be protected by legal privilege. That acknowledges it's not the sole purpose, right? It's the dominant purpose. So that acknowledges that there will be other purposes. And this was part of the problem for Optus. In fact, there are a lot of sort of technical issues around this that we don't really need to look at, but a lot of it came down to the evidence that Optus produced and the evidence that they didn't produce. So we don't actually know really what the story is, but we do know what the evidence produced. So that there's kind of two lessons there. One lesson is that sort of semi-technical one that it's not enough to make sure that you integrate the legal advice into every level and aspect of the inquiry and report creation. It's that you create enough of a paper trail so that if you're unfortunate enough to face legal proceedings as a result of a breach or an incident, that you can produce the evidence to show that it is privileged.
Yeah.
So the two aspects of it, it's got to be the dominant purpose. So that means it's got to be everything else that happens has to be for purposes of allowing the legal advice to be produced.
Now, that's on balance of probability, correct?
Yes, that's right. So it just has to, the evidence just has to show that it's more likely than not. It's not, in criminal cases, it's beyond all reasonable doubt, but we don't have to go that far. We just have to show that it's more likely than not that that's the purpose.
And that's to the satisfaction of a judge in this case.
Yeah, I was going to say the full court actually said that they were happy that the dominant purpose of the general counsel, who was also the company secretary of Singtel Optus, was to obtain legal advice. And he's general counsel, he's a lawyer. So that's kind of what you'd expect. But the problem was Optus didn't produce an awful lot of evidence in regard to the other parties who were involved, such as the CEO and the board members. And we did, the court did get some evidence in the form of some documents for the board and a media statement where all the other aspects of the purpose for producing the report were front and center, and the legal issues were pretty much, the legal purpose was pretty much ignored. And that's what sunk the case for Optus. So of course that it's just in the nature of cyber incident reports that they are going to want to address things like how it happened, what the underlying cause was,
mitigation strategies.
Absolutely. What sort of procedural management steps have to be taken to prevent it from happening again. Now those are not separate issues. Those are the very things that any kind of legal advice is going to address pretty much head on. It's going to say, okay, your obligation under the Privacy Act, for example, under APP, Australian Privacy Principle 11, is to take reasonable steps to ensure that people's personal information is well protected. Now we ask did you meet that obligation? So it's still going to be talking about the steps that you took to protect that personal information. It's just it's going to be doing it in the context of giving you legal advice on whether you've met your legal obligations or not. So these are not separate questions. And as I said, it's sort of a technical question because we don't know whether all of those, it's quite possible that media release just didn't bother talking about where the legal issues relate to the other ones because it was a media release. It was designed for a particular sort of PR purpose.
Yeah.
It wasn't designed with the idea of it being advice in a legal case
And relied upon
center.
that way. Yeah.
And that that's understandable, and it's easy to make mistakes like that in a high pressure situation such as a data breach. But it's a mistake. That the takeaway that everybody else can get from this is that regardless of possible technical errors in conducting the case and the part of Optus, is that you have to both create a paper trail to show that this is what you're doing so that you can use it as evidence if you need to, but also that you have to make sure that the legal advice is integrated into the report at every stage. It's not something that you can sort of spray on afterwards to give it a kind of Teflon protection. It's got to be there from the start. It's got to be genuinely why that report was conducted.
Which is part of planning, right? So you've got planning, and then we talk about, there's no separation if you want to achieve that level of integration, right?
Yeah, that's right, and that's why it's important. You don't have to make a huge production out of it, but you do need to have integrated the legal advice into your planning procedures right from the start. If you've got in-house counsel, that's a great way of doing that. Make sure that they're involved right from the start. Make sure you have like a privilege protocol in place. Make sure that people actually comply with the privilege protocol. You can get outside lawyers in to help. There are all kinds of ways that you can do it, but it's crucial to make sure that you have one eye on the question of privilege. Otherwise, you might as well just be mailing a copy of the report to every class action law firm out there, and nobody wants to do that.
No. So preparation is the key then.
Absolutely, like all things with cybersecurity.
Yeah, absolutely. Yeah, so whether it's a cyber incident or legal advice, and your ability to preserve the integrity of what you're trying to achieve, that planning and then integration of legal advice in the process of undertaking investigations.
I mean, it's starting to sound like a stuck record, I think, but in the same way that cyber risk should just be part of your general approach to risk, the legal advice around your cyber risk, or all risk really, should be integrated into your approach to risk. It's a way of doing risk management right, rather than an extra thing that you do to get some kind of advantage.
At
the end of it.
Just being part of the culture of how you approach things.
Absolutely, embed it in your culture.
Yeah, absolutely. Yeah, I think that's the key takeaway. Hopefully you've enjoyed this breakdown, Paul. You've really succinctly brought this to a head for us, but it sort of points to the things that we all need to consider in this space.
Yeah, and it's going to be an interesting case to watch anyway, for all kinds of reasons. So I'm sure a lot of people will be following it with great interest.
Watch this space.
Yep.
Paul, thanks for joining us.
Thank you.
Cheers.
Cheers.